Hi, my name is Phil Weiser, and I'm a Deputy Assistant Attorney General at the U.S. Department of Justice in the Antitrust Division. I'm on leave from my job as a law professor at the University of Colorado. I got my start in the world of antitrust as a student of F.M. Scherer, known as Mike to his friends. He has been a legend in the antitrust world over the past 50 years as an engaged researcher, teacher, and testifying expert, as well as serving in the government as the chief economist at the Federal Trade Commission. We're so privileged to have Mike here with us today to ask him a series of questions and get his thoughts on the world of antitrust. Mike, thank you so much for doing this.
My pleasure.
I'd like to start broadly. Over the last 50 years, you've been engaged on the scene, seeing the changes in economic learning, antitrust law, and policy. And looking back over that wide swath, what are your thoughts about how the world has changed most fundamentally?
50 years, I guess that takes us from the end of the Eisenhower administration. It was very active then. It continued active under Johnson, Kennedy, Johnson, Nixon, actually, Ford, Carter, continuously active. Then it went into a very quiet period under President Reagan and never really came out of that slump until one hopes fairly recently. Of course, that shows my biases, but we have a new administration and maybe things will change.
How do you account for that shift in the two eras you've just outlined?
Well, it's not just party politics, that's for sure, because Eisenhower had a very vigorous antitrust policy. I think it was when Ronald Reagan came in, he really thought that government was the problem, and he brought in people who thought that government was the problem, and they downpedaled, among other things, on antitrust.
The changes of the Reagan Revolution are often coupled with what's called the Chicago School Revolution. You've been a long-time critic of the Chicago School Revolution. I guess I might ask to say, how would you describe the tenets of the Chicago School perspective on antitrust law, and where do you depart from that?
Well, first, I'm a great admirer of the Chicago School. I've been critical, but I'm critical of everything. So how does it differ? Actually, it kind of pleases me in the sense that I'm from the Chicago area originally, and its early premise, that is 1950s, 1960s, was a typical Midwestern beginner premise. That is to say, if the conventional wisdom was X, Chicago would set out to prove Y. And there was quite a bit of research, mostly inspired by Aaron Director, which just lashed at traditional antitrust thought and showed in many cases that the emperor had no clothes. Now, I think it got overdone in the sense that they were out to prove the negative and did so convincingly sometimes, but didn't keep their eyes open for the positive side of things, the good things that antitrust can do.
There's a broader strand of your thinking that's worth highlighting here, which is the role of history, theory, and empirical analysis. You have bemoaned the fact that the economics profession has moved more towards the world of theory. Could you maybe explain a little bit about that concern?
Well, let's divide that. The economics profession on the one hand and the subset that do industrial economics type things on the other hand. I'll start with the second. When I was a graduate student, it was the standard thing for a person getting a PhD with specialty in industrial organization to do industry case studies. Those are hardly ever done anymore. Instead, people write papers in pure theory or sometimes intersperse them with purely theoretical, mathematical theoretical analyses. That is now the dominant trend in economics. Again, in economics generally, not just industrial organization, but economics generally. When I was a graduate student at Harvard, one was required to take a full-year course in economic history, People don't learn history anymore. They learn theory, they learn econometrics, and they kind of lose track of what's going on in the real world. My approach has always been to emphasize what's going on in the real world, and let me just go more broadly. There's a petition circulating around from the University of Cambridge in England by Jeff Hodgson, a macroeconomist. He argues, and has got hundreds of signatures on this point, that the terrible economic crisis we're having now has come in part because economists only do theory and don't learn about the real world. And therefore, we've done a lot of really stupid things.
So I want to pick up that point. You've suggested you're hopeful that the Chicago ascendancy and the more passive antitrust attitude is headed for history. And I would ask you, is that change one that you think will be because of theoretical or conceptual criticisms of Chicago, a greater focus on the empirical analysis where Chicago school theory goes wrong, or some other factors?
No, I think there's a dialogue. And the Chicago guys had a lot of good things to say. It took, if there is another organized side, that's part of the problem. If there is another organized side, it took them a while to figure out that, hey, we better look into what the Chicagoans are saying. That's slowly happening, and so both evidence and theory are changing to rebut some of the Chicago propositions. There's a major element of ideology here. If you're laissez-faire, you'll probably be laissez-faire on antitrust, too, although Henry Simons, who was at Chicago in the 1930s, was very much laissez-faire, but thought that vigorous antitrust was necessary to make a laissez-faire economy work. But again, the Simons tradition has been forgotten. And I think there are others of us who believe that, with Henry Simons, that an activist government position is required to take into account the many instances in which real-world markets do fail.
On this point about an empirical analysis, a couple different things I'd like to visit with you about. First is Freakonomics. Steve Levitt is helping to focus some of the small world examples of where theoretical predictions of how we would expect markets to work don't actually happen. And there's a new school, someone called it behavioral economics, that may, in some sense, move the profession's attitude on empirical analysis. Do you see that as a promising development? What's your thoughts on that?
As a general promising development, I think it's very good indeed. It's not new. There's been a behavioral economics around since day one. Herbert Simon was a pioneer in it. My PhD dissertation was a dissertation in behavioral economics. I have to admit I have not read Levitt, so I can't comment on him. In the last couple of days, though, I've read a couple of book reviews of his latest book, and he is being thoroughly trashed for not understanding the facts. A common Chicago fallacy.
Well, your focus on facts led you, when you were at the FTC, to engage in serious industry studies. That is something that agency had really perfected at one point, but some have seen it as sort of no longer a part of the FTC's mission. Could you talk a little about what that was like and why you think that survey was important?
Well, we did various kinds of things. First of all, the FTC does have a long tradition. It was created in 1904 by Teddy Roosevelt as the Bureau of Corporations. And its entire function, it had no adjudicative functions at all. Its entire function was to cast sunlight on industrial practice. And that actually continued even as the FTC took on adjudicative responsibilities. It continued in the 1960s, heavily under Willard Mueller. I did a couple of things. I pushed my staff very hard to begin doing industry case studies. Even in their spare time, when they weren't working on cases, I wanted them to do case studies, and we had some very good ones. The second thing is I didn't initiate them, but I pushed some statistical programs to get the kind of data that one needs really to understand how the industrial economy operates. That was partially called the Corporate Patterns Program. The other part was line of business. We got some great data for 4 years. Then the Reagan administration came in and killed it.
Would you like to see some program like that reinstituted, and how would you devise such a program?
I'm truly not sure, because something has come into existence partly to take its place. When I got that program on a firm footing, the Census Bureau was absolutely adamant that outside researchers could not have access to census data. That has changed. It changed actually in the early 1980s, I believe, if my memory is correct. And now you can get clearance to access census data. They aren't always quite as well focused as what we tried to get in the line of business program, but one can do a lot of the things that we had hoped to accomplish with the line of business program, using census data now.
What else are you proud of, and do you find as a notable part of your service at the FTC during that time period?
I think I built up a very good staff. I inherited a fairly good one, and we built up an excellent staff with really strong fighting morale. That's one thing. I really put my emphasis on our studies and on our collection of data, although I did fail in one important respect. I tried to get going a major study of the American automobile industry. I knew from my own research that the industry was headed for deep trouble. And I tried to get a major study that would illuminate exactly what was going on, and it simply bogged down and didn't happen. So that was one of my failures. On the antitrust side, we had some successes, we had some failures. I think the Xerox case was highly successful. That was a big image case. The case, we tried to get a shared monopoly case against the leading 8 petroleum companies. That was a disaster. It was simply not well based. It was an emotional reaction to the oil shock of 1973-74 and just didn't have much basis and was correctly abandoned. Our other big initiative was the breakfast cereal case. I personally testified in that one. We developed a very interesting theory, but we essentially were beaten in the halls of Congress. The lawyers for Kellogg realized that they weren't going to win in the courtroom, so they went to Congress and brought back pressure to bear on the Federal Trade Commission. And a lot of bad things happened, and eventually the case was thrown out. Not dismissed without merit, but simply thrown out as inconclusive.
One other thing that was happening that time period was an investigation of the auto companies seeking maybe potential structural relief, breaking up GM, for example. What were your thoughts on that antitrust theory and any of the potential actions that could have been taken?
My view of that was essentially eclectic. I thought there was a very serious problem in the automobile industry. One could have brought or tried to bring an antitrust case. I thought it wasn't the time to do that. The first thing one had to do was get understanding of exactly why the industry was performing the way it was, what were the dynamics, and only after that might a decision have been taken to take some kind of antitrust initiative. Now, we did have a small crash parts case, but that one really didn't go much of anywhere. I guess, well, I learned some things from the cases that failed on us. We had an investigation, a consumer protection investigation of the funeral industry, and we had one of the crash parts industry, and we had one of the breakfast cereal industry. And from both funeral, every congressman meets a funeral director almost every week. And you just don't want to tackle those guys when they have such good access to Congress. The same is true of the crash parts, the body repair shops. and the many franchise dealers. They have tremendous political clout, and they killed our case. On breakfast cereal, I think in the media we got from the Los Angeles Times a good review, and from nobody else. Moral: never tackle the biggest advertisers in the country because they have tremendous clout with the media.
So this raises a question. The FTC, from the three matters you mentioned, and more generally was viewed by the late 70s as out of control. There was talk of shutting down the agency. You've offered an explanation that's a generous one to the FTC. That begs the question, why did the DOJ in the 80s and 90s take on AT&T, Microsoft, and Archer Daniels Midland, and its reputation wasn't so sullied? Were there institutional challenges at the FTC or other explanations? And to what extent has the FTC learned from, responded to, and in some sense reacted to the experience that you've just outlined and the subsequent efforts in Congress to really put shackles on the agency?
Well, one, the political climate changed. But second, and it changed just a few years after I left the commission. But second, we were really pushing the boundaries. Against the cereal companies, we were trying to develop a concept of shared monopoly. And oligopoly cases had had a very uneven history in antitrust. We tried to push the ball forward, but basically failed more for political reasons than others. And then, of course, when the new administration came in, there was not much support. We got a bad rep for closely related reasons, too. I'll tell you a story. The way the FTC works, the staff, when a case is in litigation, the staff cannot talk to the commissioners. And so the cereal case was developing and about to go to trial. And I remember a meeting we had one day in which it was said, Mike Perchuk, Mike was the chairman, Mike is going public on his KidVid, children's television initiative, next week. And this will be the death of the breakfast cereal case. So the question was, what could we do about it? And the answer is we could do nothing because we couldn't talk to Perchuk about him and warn him of the adverse consequences. There was a problem with KidVid, but you were going against very, very powerful advertisers. And you were also challenging, in effect, parents for letting their children be influenced by the ads they saw on television. And this just created far too much backlash and led, among other things, to the appellation, the national nanny, which made the FTC, in effect, the laughing stock.
Well, I want to back up, and we'll come back some to the FTC, again to the early part of your career. You have called yourself an accidental Schumpeterian.
Yeah.
And for those who haven't heard of Joseph Schumpeter, you probably should read either the book biography of him recently, Prophet of Destruction, Tom McCraw,
yeah.
Or if you can get through Capitalism, Socialism, Democracy.
It's a good read.
It's a good read, and it's probably as relevant as ever. You said you were captivated by his ideas, yet a lot of your writings tend to disprove some of his conjecture. Maybe can you explain a little bit your interest in Schumpeter and how your research has essentially filled out what you've called Schumpeterian Perspectives?
Well, my big thing, Schumpeter's big thing, was that it wasn't the fine-tuning of the price system that led to national prosperity. That's what Adam Smith partly emphasized. Rather, it was dynamic technological change, with productivity, output per unit of labor input growing at roughly 2% per year. That's what made us rich. I mean, really, over the long run, it has a tremendous impact. And that was Schumpeter's main message. It had not been accepted by other economists. It had not been even taken up by other economists. So Schumpeter captivated me on that. Now, in Capitalism, Socialism, and Democracy, 1942, he went farther and said, not only, well, he revised his previous view. His previous view said that it was the outsider, the small startup firm, that introduced technological innovations. In 1942, he said, no, it's big business, it's monopolistic companies, large companies, entrenched companies. They're the ones who now do the most research and innovation. And I was very taken by that. Again, I go back to my Illinois roots as an beginner. That was again everything economists were teaching, and I thought, this is wonderful. I want to do research on it, and I did quite a bit of quantitative and qualitative research and found that it simply wasn't supported. Now, this came at an unfortunate time. Capitalism, Socialism, Democracy appeared in 1942. The first American high-tech venture capital firm was formed in 1946. And the leading edge of our innovation has been our high-tech firms, not our big businesses.
So Schumpeter might have looked at a company like AT&T and Bell Labs and cited that as an example of his vision of creative development. AT&T did develop the transistor, Unix, others.
Magnificent. There was an article in 56 or 57, I think it was by Francis Bellow, the world's greatest industrial laboratory, and that was Bell Labs, and it was true at the time.
So
they were great.
Where is Schumpeter's prescriptions, let's say, as to Bell Labs, off the mark?
Bell did wonderful fundamental research in nuts and bolts technical telephone technology. It was much more laggardly. When I was at Harvard Business School working on a research project, I did a case study of Bell's innovation of microwave radio relay, and I realized that unless they were severely threatened by competition, they went very slowly. Now, this microwave radio relay, TD2, was different in the sense that there was a clear and present danger that somebody else would grab that monopoly, and then Bell had the fastest R&D project you've ever seen.
How do you take this concern about innovation competition? Clayton Christensen called it innovator's dilemma, where the incumbent won't necessarily innovate until they realize that their own existence is threatened, because otherwise they'd cannibalize themselves. How do you take that premise and operationalize it? What sorts of antitrust doctrine or cases can follow the insights that you've sort of helped develop?
Well, again, I think it's a question of methodology. These are very messy issues. The only way one can get into these is to delve very deeply with into historical data, and here places like the FTC have an important role to play. For there to be historical data, somebody has to get them out, and that's the job of the FTC, to tease out through its studies and its cases, the latter aided by the Antitrust Division, to get the information in the public domain and let the economic historians go to work.
With respect to the AT&T and the Microsoft cases, both those cases in some sense relied on concerns about suppressed innovation by a dominant firm. Do you see those as successful, either as a matter of contributing to the doctrine and to the industries that they focused on? What's your evaluation of those cases?
I always had mixed emotions about AT&T. I kind of felt that AT&T truly was a natural monopoly, and I was reluctant to break it up and rejected an invitation to participate in the case. But I also knew that when threatened, AT&T did accelerate its pace of technical change. And so the problem is to, in one way or another, to keep the threat open. Now, Microsoft was a similar type of case, and frankly, I'm unable yet to evaluate because things are changing again. Frankly, I don't know. I testified against Microsoft in Luxembourg in the first European Commission case, and I thought that Microsoft, in fact, had done some really bad stuff in media players. But the amazing thing about that field is that new threats keep coming up, and one cannot rest on one's oars.
Well, I know you also submitted a brief with Bob Lighton and Roger Knoll, among others, in the Microsoft remedial context, focusing on structural relief as opposed to regulatory relief. Do you have views in the unilateral conduct context about divestiture and structural relief versus regulatory relief? And if so, what are your thoughts?
Well, the writing of that brief was an interesting bit of bargaining. My colleagues on the brief were mainly interested in structural relief, breaking Microsoft up horizontally and vertically. I thought that if the basic code were made publicly available, that competition might well take care of itself. My colleagues were less enthusiastic about that view, but we struck a deal. We'd have a strong pitch for licensing of technical interfaces, licensing of source code, and so forth. We'd go that way, but we'd also agree unanimously on the recommendation for structural reorganization. I was skeptical about the structural, because how do you break up an operation which at that time had basically only one R&D campus at Redmond, Washington? I was puzzled about that one.
You have had a lot of writing about compulsory licensing and antitrust oversight of intellectual property. The Microsoft case involves a recent example of that, but your work goes back really over these past 50 years. Over that time period in your important writing, what are some overall thoughts you have and suggestions about the role of antitrust and its relationship to intellectual property?
Well, the first and most important thing I have learned, and I learned it a long time ago, 50 years ago, was that much to my surprise and to the surprise of everyone, intellectual property normally, there are exceptions, intellectual property normally plays a relatively minor role in protecting companies so that they can invest positively in research, technology, and innovation. That's the most important thing. There are exceptions. The pharmaceutical industry is a probable exception. But that's the most important thing that we found. Second, from analyzing particular cases, I have found that surgical intervention, among other things, under antitrust can have very beneficial effects in some cases. It did in the Xerox case, which ended in a major licensing decree. So I would say that one first should understand what one's doing. But second, then, not be timid. But if there's a problem, go in and fix it, if need be, with mandatory licensing.
The courts have shown a high degree of hostility towards the suggestion of antitrust mandates in the IP area. That has come up in different cases, and I wonder if you might have any insight into why there is such a strong reaction against the argument you just made.
I don't understand it, to be honest. It was not true forever. There were major cases that went all the way up to the Supreme Court in the 1940s and 1950s, in which the courts, following from literature that developed under the temporary National Economic Committee investigation of the 1930s, finding that, or arguing that patents were having adverse effects on the quality of competition. Now, economists have developed a very strong empirical literature supporting that point, and supporting, more importantly, the point that there are lots of other first-mover advantages that substitute for patents, and that the world of innovation by no means ends when you weaken patent rights. I do not understand why the antitrust agencies, and for that matter the courts, to go to your question, why they haven't understood this.
Over the last 50 years, you've worked with a lot and seen a lot of economists and lawyers in the worlds of antitrust, industrial organization, and innovation. Who would you say are some of the great leaders and people you think are either sung or unsung for their accomplishments and qualities?
Well, that goes in two dimensions. One is sort of theoretical and ideological and the like, and well, the person who comes most readily to mind is Bob Bork. He made major contributions. Dick Posner made major contributions. Don Turner and Phil Arita made major contributions along this line. And there are quite a few others that I offend by omitting, but those are the ones that come to mind most immediately. Then there are great litigators, those who can get into a courtroom and get the job done. And again, I risk offending a lot of people with whom I've had no contact in that context. But the two who come most readily to mind are David Boies, who cut me into hamburger for being unprepared in U.S. versus IBM. I learned a lot from that very bad experience. And in the what was really quite an important case in the 1980s when Mobil Oil tried to take over Marathon Oil. There was quite a much publicized trial in Cleveland in which Marathon tried not to be taken over by Mobil. And that pitted George Stigler, who's the only person, well, not true, who at that time was the only person in economics who had the Nobel Prize, versus little old me. And I worked with Patrick McCartan of Jones Day on that. Patrick was just an absolutely superb litigator and cross-examined George Stigler and won our case.
So present company excluded, yourself namely, what economists stand out to you over that time period?
What economists stand out to me? That's
George Stigler, I take it, would be on that list?
Absolutely, yes. I've learned a lot from Harold Demsetz. I've learned a lot from so many different people. Mike Spence has done seminal work. There are just I learned a lot from Jeff Shepard, my colleague at the University of Michigan. That's a huge array. If you look at the footnotes in my textbook, you see hundreds and hundreds of economists, and there are quite a few who get at least a dozen citations. Joe Bain was very influential on my work, for example, but not on antitrust. Joe didn't do much on antitrust.
Well, I wanted to ask you about that book. That book shaped the field. It's often known by its initials, IMSEP, for Industrial Market Structure and Economic Performance.
That's the way I characterize it.
It's often referred to as the Bible of what some have called the Harvard School, or others have called sort of the modern field of industrial organization, the structure, conduct, performance paradigm. What inspired you to write that book? Do you feel it accomplished what you set out to do, and how do you see its impact?
Well, when I was an assistant professor at Princeton, I was teaching the basic industrial organization course. And there were a couple of things, minor things, but there was essentially only one textbook, Joe Bain. Now, Joe Bain is was then the big guru in this field, who followed on to Ed Mason and established a paradigm for how the field of industrial organization would operate. I was very dissatisfied with Bain's approach. Perhaps the most important part of my dissatisfaction came from his emphasis on pricing and pricing behavior, and there was no technological change in his model. So I felt one needed a model that had technological change in it. So that was one thing that dissatisfied me. And also, I felt that one needed something that was more treatise-like, that went into the huge body of literature and tried to synthesize some sense out of that body of historical and empirical literature. And third, my approach to it was, I think, quite different from most industrial organization economists then, and even more so today. I was a student at Harvard of Tom Schelling. Now, Schelling got the Nobel Prize for his work on cooperative game theory, where you have two parties, rivalrous parties. How do they work together to get a mutually advantageous result? That which had also been emphasized in Edward Chamberlain's famous book, that was the main thing for me. Most economists, on the other hand, prefer the mathematical elegance of Cournot-Bertrand models, where you can conjure up a set of equations and from those equations predict how companies will behave in an industry. And unfortunately, that theory has very little empirical basis, and what that theory predicts is often greatly at odds with the real world. So my whole approach was to mix the real world, what we know about it, with a solid industrial organization theory.
Well, I think that's said very well, and I think many would say is your signature, and it's quite a legacy you've left. One area that thesis can be tested in is in merger review, where you've done some real work that shows many mergers, indeed most mergers, end up not being efficiency enhancing. My question to you is twofold. One is that true generally across the board with what you might call strategic mergers as well as conglomerate mergers? And to the extent one has that view, how does that influence the overall assessment of the whole merger review program by the antitrust agencies?
Well, I guess I'd say three things. Number one, in my view, and it turns out when you Google my publications, in Google's view too, the best book I ever wrote was my book on mergers, which was a study of conglomerate mergers, and we found that on average they had been a failure. Now you raise the question of strategic mergers. I readily admit some mergers yield tremendous benefits, but even now the consensus of the trade press is that most mergers fail. Most mergers fail to yield value for the stockholders, fail to yield value for society. Economists are much too reluctant to accept that because there are nice theories that suggest that mergers do yield benefits, but they have big problems. So to the antitrusters, I would say, do not be afraid. Do not fear that an intervention will cause inefficiency. Know what you're doing. Study the facts. There will be cases, I testified in one such case, where the efficiency benefits greatly outweigh anti-competitive benefits. But know your facts and then proceed aggressively if there are going to be anti-competitive effects.
You've mentioned a couple of points, your work as a testifying expert. You've been in some pretty important cases, U.S. versus IBM, the FTC case against Intel, Toys R Us for the FTC. When you look back on your career as a testifying expert, what cases, experiences, and insights stand out?
Well, quite a number. I liked the merger case involving Archer Daniels Midland and Clinton Corn Processing because, to my knowledge, it was the first time that an efficiency defense was actually litigated. Turned out the judge didn't want to touch it, but that was unfortunate. I enjoyed Mobile versus Marathon because my approach to market definition there was based on earlier work I had done in a merger case, 1972, Associated Brewing being taken over by Heilmann's Brewing. And in that case, I basically used the logic of what came to be the SNP test. So I'm very pleased about that. I was pleased in Toys R Us because Toys R Us had made a big thing out of a free rider defense. And we showed empirically, we showed from the evidence that there just wasn't any evidence of significant free rider benefits from Toys R Us's policies. And I was just delighted when Judge Diane Wood essentially said, you guys got it right. Intel was kind of really, really interesting, I think. It never went to trial. This is the case in the late 1990s. I was economist for the Federal Trade Commission, and there were a couple economists on the other side I won't mention. It was about to go to trial. Now, if I had one thing I would insist upon with antitrust enforcers. Before you go into a big monopolization type case, know what your remedy is going to be. A couple of weeks before the case was to go to trial, I had deposition taken from me from Mike Denger, who had been an old friend, and we had a very pleasant deposition. And after the usual couple of days on the narrow merits of the case, Mike examined me for quite some time on what remedies would you oppose. I had never talked to counsel about the remedies, but I had thought deeply about potential remedies. So I laid out what I thought appropriate remedies would be. And so the deposition ended at that. And I walked out of the room with Will Thom, T-H-O-M, who was the senior FTC guy on the case. And Will said to me, "You know, I think they're ready to settle." And 10 days later, they settled. I thought this was a major accomplishment, getting a good settlement without all the cost of litigation.
To your mind, when you look back again over this broad swath of history, 50 years, what antitrust cases do you think are most important, either for the precedents they established, how they were litigated, or bringing economic learning into the doctrine?
Over the last 50 years. On the monopolization front, Matsushita and the Liggett and Myers cases were absolutely critical. I'm not altogether happy with the precedents that were established, but I thought they were pretty good. Oligopoly, non-collusive behavior by jointly acting oligopolists remains outside the reach of antitrust. This is a void that I think needs to be resolved. In vertical cases, I think we're making slow progress. Toys R Us blazed a trail, and the issues in Legion, the Legion, L-E-E-G-I-N case, I thought were pretty well handled by the Supreme Court. I've always agreed that a rule of reason approach was right, but the Supreme Court could have gone overboard there and said, and made it really hard to bring a case against a vertical restraint. But the Supreme Court came out to a balanced view that said, these things sometimes do great social harm. It remains for the future to figure out how to handle them.
Well, you helped them out with a really good amicus brief in that case, so you deserve some credit there.
I don't know if it had an effect or not. It got cited a lot by the court. It was certainly my intention to get the court to admit that there could be disbenefits from vertical restraints as well as the well-proclaimed benefits.
So, again, you've talked about a number of issues. One I want to go back on, the FTC has a Section 5 power that's broader than Section 1 or 2 of the Sherman Act. Do you have a view as to how to think through and guide that authority?
I have a view from my experience at the FTC. The most important thing is to know your turf, to understand the industry thoroughly. And you don't understand the industry thoroughly unless you do investigative studies. That, I think, is the main, one of the main reasons for having a substantial research function at the FTC. It's not well known. But the Standard Oil case rested on the work of the staff of the Bureau of Corporations. That case was a whole lot easier than it might have been because of their work. The United States Steel Corporation case was similar, turned out against the government, but one needs a strong analytic base, I think. That's the most important thing. And if you get the facts out, I think most courts will decide things correctly.
Mike, another thing that you've seen and you have a sensitivity to because you spent some time in Germany and your wife, I believe, is from Germany.
Correct.
So the world has gotten antitrust. When you started in this world, the U.S. may have been one of the only antitrust authorities of any note. Now there's literally scores of antitrust authorities, and the EU has developed a developed system. You've testified in front of them. How can you describe the globalized nature of antitrust and what impact that's had?
Well, several things. One, the EU, EC, I guess one should say, has become more aggressive than the American antitrusters, and in some senses that's a good thing. I think they've gone into areas where we either dropped the ball or bungled the ball. On the other hand, I have real problems with some of the European Commission cases because I testified in the first European Microsoft case, and the EC operates in such a way that they give the impression they are serving as a complaint bureau for aggrieved competitors. I think that's wrong. I think it's wrong to give that impression. The impression is undesirable. Whether the EC believes it's doing that or not, I don't know. But that is certainly the impression they convey, and I wish they'd get away from it. I think it's giving antitrust a bad name. They should do their own analysis. They should present their own witnesses. I was there as a witness on behalf of real networks, and I felt that was not the context that they needed to resolve that case.
You've offered a number of lessons that I want to try to quickly review and see if you have others you'd put on your top 5 list, as it were. One is the importance of data and empirical analysis to understand the industry context. A second one is be prepared, but don't be timid. If you've got your facts behind you, to test your theory and not be afraid to try to move the doctrine in areas that would address competitive harm. A third one...
Let the courts sort it out with well-argued prosecution and defense.
A third one is, I take it, don't be afraid to be contrarian, test conventional wisdom. And it sounds like one of the conventional wisdoms that you're uncomfortable with currently is the view on intellectual property, and your recent article on that talks a little bit about that. What other sort of lessons and signatures of your views and wisdom might you put on that sort of top 5 list?
Oh, that's very hard. I guess I've been a beginner on the accepted Chicago view favoring vertical restraints. I did some work in the 1980s on that. Bob Bork had a very, very nice proof of why vertical restraints, by giving retailers more funds with which to do aggressive marketing, benefited consumers. I proved the counter example and showed that that was a special case. It can happen, yes, but there are alternative cases. I think that's one of the things I've had a little bit of success on. And I do believe that in the merger area, some of the things I've done have been useful. My approach to market definition, I don't know if it influenced the actual adoption of SNP or not. I truly don't know. I haven't been able to get the truth out there, but it certainly set a pattern for doing that. And I don't think I've been as successful on the other aspect. I don't think there is enough skepticism over the benefits of mergers that have anti-competitive effects.
Well, my final question for you is, you're path-breaking as a scholar and as a practitioner, but your teaching is something special. A lot of people with your credentials don't care about teaching, don't invest in it, but I know from personal experience how much you do. Maybe a word or two about your thoughts over the career as a teacher. I know for all the students who benefited from you, we're so grateful. Why have you invested so much into the art of teaching?
Well, I just love teaching. I like the interplay in the classroom. I guess I like to get up there and expand my view of the world, which may be a bifurcated view or a trifurcated view, but I like to get up there and pose the issues for the students. And I guess at least the way I've been teaching recently, and I'm still teaching at a fairly advanced age, the way I've been teaching recently, I push the students to take to write policy papers and to take a position one way or another in some great issue, and I enjoy that, and I enjoy forcing them to think their way through a problem. And
we've enjoyed it thoroughly, and I want to thank you so much for your time here today. This is a wonderful way to capture your essence, share with people who haven't learned from you, and remind us all of the wonderful lessons that you've sort of thought through. And thank you again so much for taking the time.
My pleasure. Thank you very much.